Hey guys, it's Tyler Flood. Let me know if you can hear me okay. I'm coming to you live from Chicago, the Windy City today. You see the beautiful background here of downtown Chicago. And we're going to answer some questions today about DWI. I am up here in Chicago for training at Axion Labs. It's a laboratory that allows attorneys to come up and learn about gas chromatography and mass spectrometry. And this trip we're learning about solid drugs, how to test blood for solid drugs, how to test drugs to make sure they're actually what the police say they are. So it's really interesting and unique and exciting training. I'm lucky to be here, but had to take a step away to answer some questions. I see that we have a new visitor on this web chat. Philip Burnett, thank you very much for joining us, and I will answer your question. I wanted to show you guys some things. These are little vials that were collected from the laboratory. So if you can see these, and these just have, they're tiny little vials, much smaller than a blood vial. They have a screw on top, and what you do is when you mix drugs in a vial or blood, you put a solution into this little vial, and then this goes into an auto sampler, and a robotic arm comes down and pierces the septum with a needle, and it injects it into the gas chromatography machine, and then it produces the results. So I just thought it'd be kind of cool to show you some of the actual vials that they use for drug testing. All right, well, let's get right to it. I'm going to go ahead and start with Philip's question, since we always are welcoming guests to the web chat and we want to help out as much as possible. You can email me questions before Fridays at 2 o'clock using tyler@tylerflood.com or office@tylerflood.com. And our phone number is 713-224-5529. I'm a Texas DWI attorney. My practice is dedicated exclusively to DWI defense. I focus on blood and breath cases. It's definitely a different animal, and you got to know what you're doing, or else you're not going to be able to do it right. So Philip's question is, how do you propose to challenge prior DWIs when a defendant does not want to stipulate to them? And then the other part of that is in the indictment or at sentencing or where. So this is a situation where you have a felony DWI and there were at least 2 prior convictions. And that makes it a felony if you get charged with a third. I've tried many of these cases, and I've only lost 1 felony DWI in my entire career, 14 years. We also handle intoxication assaults and intoxication manslaughters. Most attorneys are very scared to try felony DWIs. They think that, and the reason is because the jury gets to hear about the 2 prior convictions during voir dire when you're even just selecting the jury. It's a part of the case that the state has to prove. If they can't prove that there were 2 valid prior convictions, then it is not a felony DWI. And so the way that this is proved is through getting the judgment and sentences from those prior convictions. The state has to list those in the indictment, and they have to present those to the grand jury to obtain an indictment. Otherwise, the felony court doesn't have jurisdiction. It would just be a misdemeanor. At the trial, they have to prove up that there were 2 valid prior convictions, or else the jury can't convict a person of a felony DWI. So there are different strategies on how to handle those convictions. And I don't ever make a general rule about how to handle anything on any particular case. Some lawyers will tell you, I think, who are less experienced and who haven't dealt with this issue in trial, just that you should stipulate to prior convictions all the time, because then the jury doesn't get to hear as much about it in trial. Sometimes you don't want to stipulate to the prior convictions if there's a problem with the state being able to prove them at trial. So I would say in my cases, half the time I have agreed to stipulate, and the other half of the time I have not agreed to stipulate. And I'll tell you the reasons why. One reason is, well, I'll tell you, my rule across the board as far as what I tell the state is that I don't know if I'm going to stipulate to the prior convictions or not. When I say stipulate, that means that you're not fighting that they are true, and you're just going to agree that they are true, the prior convictions. That's what it means to stipulate. We won't contest that, Judge. We'll stipulate that those are true. But then that takes some of the burden off of the state of having to prove beyond a reasonable doubt that those are valid convictions. So I want to keep the state, guessing, because if we don't stipulate to the prior convictions, they have to prove them to be true. Some of the reasons why we won't stipulate is if they have trouble proving them up. So we will have obtained the paperwork beforehand, the judgment and sentences, and we will scrutinize all of the language in there, and we'll look at the date to make sure that it's the proper date, the proper court, and everything that they put in the indictment to get the indictment. We match it up with the language on the judgment and sentence, and then if there's problems with that, we might want to lay behind the law, and we realize that they will have a problem proving up one of the prior convictions based on the judgment and sentence. So we wouldn't want to stipulate to that. They might not be able to prove it up during trial, and then they can't convict of a felony. So one of the main problems that we find with a prior conviction and proving it up is that there could be a missing thumbprint, or it could be a bad thumbprint. It could be smudged. There could be no signature from the person or his. So they have to match it up. They have to prove that that prior conviction matches that person that's on trial. And on the judgment and sentence, if they don't have a thumbprint or a signature, there could be another person with the same name and same date of birth. That doesn't prove beyond a reasonable doubt that there was that person on trial. So if you know that there's a problem with the judgment and sentence, why would you ever want to stipulate to it? That's just saying, you know what, I'm not going to fight that, and we're just going to agree that that is a valid prior conviction and you can use it freely. We don't want to do that all the time. And there have been cases where we have, so what happens if you don't stipulate is that during trial, we say, Judge, no, we're not going to stipulate to those, and we're going to require that the state prove them up. Well, then the state has to bring down extra witnesses, and sometimes they may not have those witnesses available. For instance, if there's a bad thumbprint and they can't match it up, they have to call an expert in fingerprinting to come to court, fingerprint, and then try to match it up. Or if there's no thumbprint, they're going to have trouble matching it up, and that might be a bad prior. If there's dates that are wrong, if it doesn't bear the person's signature, then we wouldn't want to stipulate to that. We want to make they prove it up, and that can be difficult. There's also a case called Samudio, S-A-M-U-D-I-O. Before 1983, there was improper jury waiver language, and you always want to look at that to see if that's a proper. Basically, Samudio said that the language for this to be a proper conviction in the judgment, the language needs to state that a jury, if a person pled guilty, it needs to state that the jury was waived. The language that was contained in the pre-1983 case is what they would say, no jury having been called. And the court found that that was insufficient to prove that the defendant waived a jury. It's very technical language. So if you have any pre-1983 judgments, you got to look for that language. If it doesn't specifically state affirmatively that a jury was waived, they can't use it as a valid conviction. So that's another reason why you would never want to stipulate, ever. I see attorneys not putting much thought into it, and they'll stipulate, and I'm wondering why. You can't have a general rule. Did you look at all the language? Did you see if it's a valid prior conviction? Can they prove it up in trial? Occasionally we would stipulate, but we want to keep the state on their toes, though. And if we find out that, if we say that we're not stipulating, and then we know that the fingerprint expert is available, then we might stipulate if they have no problems proving them. But if we find out that they can't, they might not be able to get them into evidence. So you don't always just say we're going to stipulate. But it takes a lot of work looking at the prior judgment and sentences to see if there's any flaws in there that might cause them to have proof problems, saying it was the person on trial. I hope that answers your question. So the second part was in the indictment or at sentencing or where. Yeah, we if there's a problem with the prior convictions listed in the indictment, you would file a motion to quash typically before trial. A motion to quash isn't timely unless it's filed. It's not timely if it's filed on the day of trial. So, but that's basically what I like to call a motion to fix, because it gives the state notice that there's a problem with their pleadings, and it allows them to just amend it or re-indict or fix it. So sometimes you don't want to do a motion to quash. If you don't file a motion to quash before the day of trial, then some errors in the indictment are waived. You're foregoing that opportunity to raise that on appeal. But the way that I would fight the priors, if we're not going to stipulate, that does come up during trial. During the guilt-innocence phase, the state would offer exhibits to show that there were 2 prior convictions, and if there were problems with them, that's where I object. And we might have a hearing outside the presence of the jury. We might just do it up at the bench, but we would go up and I would state my legal objections, and the judge would have to make a determination if they came into evidence or not. If we do stipulate to them, then that limits what the state can talk about. They're allowed to introduce the documents, but they're not supposed to go into the facts of what happened, so the jury doesn't get to hear as much about it. If we don't stipulate, then the jury has to, the state has to do a little more work and put a little more evidence on the record, and the jury gets to hear more about those prior convictions, which could be damaging to the case. But again, this is something that I would have already covered thoroughly in voir dire. I think the reason I've had such success trying felony DWIs is that we actually get the right amount of time to conduct a proper voir dire. In misdemeanor court, they try to limit you to 20 or 30 minutes, some arbitrary time limit that you just can't get everything done that you're supposed to do. In felony court, I've rarely been limited, and if I can get an hour to 2 hours to voir dire a panel of 60 people, I can weed out the ones who are not able to set aside the prior convictions and who can be fair in this case. We've also busted a lot of panels when people say they can't put those aside. They think if you've done it twice before, then you've done it again, you're already guilty. So that's why voir dire is crucial in a felony. So anyway, I hope that answers your question. Go ahead and submit them. I'd be happy to answer them. We actively take other cases other than DWI. And if there's a companion case or like another case that happened along with the DWI, we'll take that, like arrested for DWI, or evading the police when they were trying to pull over. Shelley, yes, everybody's not asking questions, so I'm going to move in closer to my practice is dedicated exclusively to DWI. And I think that's really the only thing that you can do to do this job the right way. You got to focus on one area, and then become effective at it, become good at one area. It's such a specialized area of law that you don't want to handle other things. I wouldn't handle murder or assault cases or anything like that. So no, I just handle DWI cases. Hang on one second. How are we doing now? I don't know if that's any better. Okay, it looks like it is. So send me some more questions, please. Did that first question come through? So another person says, I met with an attorney about my DWI, and he said that the ALR hearing is a waste of time. Is that true? That's absolutely not true. As a matter of fact, that's the definite way you can tell the difference between a real DWI attorney and someone who just dabbles in it. That's the real key. And I tell people, if you're looking for another attorney, if they don't hire me right on the spot, which normally happens, I tell them, I say, here's some questions that you can ask other attorneys, and you'll know right away if they're a real DWI attorney or not. Ask them if they handle their own ALRs, ask them how many they win, and ask them their thoughts on doing it live versus telephonically. You don't ever want to do it telephonically. I think we covered this in the last session, but ALR hearing, there's two reasons to have this. One is you want to try to save a person's license from being suspended, which makes a lot of sense, right? I mean, you don't want to lose your privilege to drive. The other reason is because you can subpoena the officers to be there at the hearing, and it's like a preview for trial. You know, we don't get depositions in criminal cases, so this is the closest thing that we have to a deposition. You can question the officers on the record and examine them about all aspects of the case before it ever goes to trial, and then you get a bunch of great and potentially impeachable testimony from the officers, and you learn about their administration, sobriety tests, and things like that. So it's crucial. We win about 95% of our ALR hearings. Most officers don't show up, but you follow the rules properly to give yourself the chance to win. Okay. Let's see what else we got. Thanks for the questions, guys. It's fun. I like coming to see from different towns where we are. Okay. If you ever hear an attorney say that ALR hearings are a waste of time, you get up and leave that meeting. That person's not a DWI attorney. How about this? Well, Philip's got another question. We're going to try to focus on how to hire a DWI attorney, but man, I sure am thankful to have people watching and people submitting questions. So we're going to just keep doing that. Philip asks, what is a proper response if police are accused of eavesdropping at the hospital after an accident on a privileged conversation between a defendant and an intake nurse, resulting in a defendant incriminating him or herself orally? Well, I know you've probably researched this. I know there's a doctor-patient privilege to a certain extent. I would assume it would also cover agents of the doctor, meaning a nurse as well, but I'm not positive about that. Some things that you say that are intended for a medical diagnosis may not be privileged. But an officer who just overheard something, that's easy. You would object to hearsay because it's not something that he learned from you. It's something he overheard. I mean, that's classic hearsay. Also, you know, it's kind of interesting, though. That's a good question, because if the person is not under arrest, they have a hearsay objection, which I don't agree with. But let's say you're out at the scene, or even if you're at a hospital and they haven't done any sobriety tests, they don't even know if they're going to be arresting you yet or not. They can ask you all kinds of questions without even giving you your Miranda rights. And the courts of appeals have carved out an exception, saying it's a probable cause exception. You're completely in custody. They're completely interrogating you. But whatever you say can be used against you if they say that they were trying to still investigate to form probable cause. It's pretty much crap, if you ask my opinion. But definitely, if the officer overheard something, we would have a lot of objections to make. Let's say, though, that you were in custody, you were under arrest, you'd already been arrested and like read the DIC 24 asking for a breath or blood specimen. You cannot be, any of the questions that you are asked and the answers that you give, they can't be used against you unless you're first advised of your Miranda rights. So that's the way that works. So anyway, okay, let's do another. What if I already hired a lawyer and I realize he doesn't know what he's doing? Am I stuck with him? No, you're not stuck with an attorney. You have the right to be represented by whoever you want at any time. And this is a common issue that we deal with. I'm hired to take over cases for people who realize that they hired the wrong attorney. They hired someone who just talked a good talk, said they were a former prosecutor or something like that. They prosecuted a ton of DWIs, but when it comes down to the technical cases like breath and blood draw cases, you've got to have an expert. And so people come to me. It doesn't take them very long to figure out that attorney doesn't know what they're doing. And they come to me, we have a meeting. They realize that I know what I'm doing. I specialize in this area. So we will do a motion to substitute. And the client doesn't even ever have to talk to the other attorney. Again, I can handle it for them, and we handle it very professionally. We would call over to the other attorney and just say that we've been hired on the case and ask if I can sign his signature on the motion to substitute with his permission. It's usually very cordial, doesn't cause any bad feelings, but at least not on our part. And the client, fire engine going by, but anyway. So most judges, though, if you try to hire somebody else and fire your current attorney when it's very close to trial, sometimes the judge will not let the other attorney off the case, but they'll say you're happy to have as many attorneys as you like, and Mr. Floyd can certainly come onto the case, but I'm not letting the other person off, and that's fine too. You can have as many lawyers as you want on your case. I would just step in and be the one trying the case. All right. Should I testify at trial? If you got any more questions, please go ahead and submit all of them to me right now. That would be great. I've only got one more question pending at the moment. Should I testify at trial? Well, that's not an easy question to answer. Normally, my clients don't testify at trial, and the reason is, if you're up there on the witness stand, you raise your hand and you swear to tell the truth. And if you lie, it's perjury. So if the truth is that you had too much to drink, then you probably don't want to take the witness stand. And this is a common question people have. They think, am I going to be forced to testify? Well, that's the other thing. You can't be forced to testify. The state does not have the right to call you to the witness stand. You have a Fifth Amendment right to remain silent, and nobody can force you to take the stand and answer questions. So there's been a few times where my client has testified, and that is when there's a good story that the jury needs to hear. One time it was I still remember the client very well, and it was the subject of the Houston Press cover story that they did on me in 2009. He was a big Russian guy that was dating this cute little Russian girl, and he went over to her apartment and brought a bottle of champagne. And he told me, Tyler, I had 2 glasses of champagne. And this guy was like 6'3", 240, 250. 2 little glasses of champagne weren't going to do anything to him. But they got in a fight, not physical fight, just argument. It was a lover's quarrel. And he was very angry and ran through a red light and smashed into an HPD officer's car. He failed all the sobriety tests, but you know what? His story was just that he was over there. He brought her flowers and champagne, and he testified that he had 2 glasses, and she testified that he had 2 glasses of champagne, and he was not intoxicated. And I think the jury believed her more than him, but we got a not guilty on it, even though they testified that he was intoxicated based on his performance of the sobriety test. So I had a client testify recently also. When there's a good story that shows that you were not intoxicated, then taking the stand is a good idea. If you take the stand and the story is going to be you were at a bar getting drunk and you had way too much to drink, then we're gonna just hold the state to their burden of proof and try to create some reasonable doubt, and you probably shouldn't testify. But there's not much risk in going to trial, though, on a first or second offense, DWI, even a third offense sometimes, because if they're offering you probation as a plea bargain and you go to trial and you lose, you're pretty much going to get the same thing. So that's why we try a lot of cases. But okay, let's go on to a different question. What if I have a prior conviction? Will the jury more likely convict me because of that? That goes back to what Philip was asking about. That's a great question. I think human nature is that a jury will likely use a prior conviction against you, and they think if you've done it once, they see a repeat pattern of behavior here, and that you probably are guilty of it again. That's obviously not the type of juror that we want if we're going to trial. So, I mean, even it's hard. It's hard to put that aside and to just judge this case based on this set of facts alone. But the law says that you have to put those aside and just consider the facts of this case. In a misdemeanor DWI, even if you have a prior conviction, that's not admissible as evidence. But on a felony, obviously, they have to prove up the 2 prior convictions. So the jury does get to hear about that. That's why we spend so much time in voir dire asking them if they can put those aside and just judge this case based on these facts alone. And when I'm given enough time to do that, I mean, we beat out probably 30 jurors or more out of a 60-person panel who say that they cannot put those aside. And I'm able to disarm them, have an honest talk. I'll tell them, I'll say, look, I think that I would have trouble as well. So I don't blame you if you can't put those aside. And we get rid of all the ones, they're struck for cause by the judge if they say they can't put those aside and just judge on this case alone. You're not allowed to use prior convictions in any way to consider if a person is guilty of the current case that they're on trial for. Philip, thanks again for another question. We'll go ahead and take that one. What are your feelings on submitting a sentencing memorandum? Is this best done before trial? I know you had emailed me about this, but yeah, we don't typically do that, especially on cases like this. We can prepare. This is where in Texas we have a bifurcated trial system. There's one portion. The first portion is to see if a jury finds you guilty or not guilty, and you only go on to the punishment hearing or punishment phase if the jury finds you guilty. So that's where we would present any mitigating evidence. You can testify there. You can talk and tell the judge everything you want the judge to hear. Certainly, we can submit a brief if there's things that you want the judge to take notice of on paper. I think personally, testifying or presenting it in person live to the judge is better, but you can submit something in a brief if there's this goes for anybody. If you've been doing any rehabilitative classes or therapy, anything that you want the judge to consider in punishment, we can submit that proof of that in the punishment phase of the trial. It doesn't hurt to have those documents prepared ahead of time, but the same rules of evidence still apply on the sentencing phase. So we can't just submit something and assume that it's going to be considered. Hearsay rules still apply, but that's certainly something that we can discuss and figure out how to do it. If there's generally a brief that you would submit to the court is to raise the judge's awareness to certain case law that they might not otherwise know. But you can't just freely submit a packet showing, making statements of everything that you've done. You would have to testify, or you would still have to follow the rules of evidence and get everything into evidence properly. I hope that helps. But a lot of times if there's legal issues and we're asking the judge to suppress evidence and it's something that is novel to that judge or it's complicated, it is appropriate to submit a brief pre-trial. I see a lot of attorneys submitting a brief during trial, and it's lengthy and there's case law to read. The judge isn't going to have time to read that if you want them to make a ruling right then. So out of courtesy to the court, it's better to submit stuff like that beforehand. But sentencing is a little bit different. All right, done with that one. All right. What are the best and worst case scenarios of the outcome of a DWI? So basically a first offense DWI, the range of punishment is up to 6 months in jail and 2 years probation. And you could get up to 30 days in jail as a condition of probation. So if you went to trial and lost, the worst case scenario is you can end up on 2 years probation and have 30 days in jail. And that you'd have to do day for day. There's no credit given if you're doing jail as a condition of probation. That's the key right there. If it's as a condition of probation, it's day for day. Realistically, you wouldn't get that, though. If it's not an egregious set of facts, you would get, at least in Harris County and most of the other counties around the state that I practice in, about a year probation and no jail time. So there's really not much risk of going to trial. If there was an accident involved, you might get a weekend in jail and probation. Yeah, so now the best case scenario is we want to get the case dismissed before trial. If you can get a dismissal, then you can get it expunged off your record eventually. If we can't get it dismissed before trial, then we want to go to trial and get you a not guilty verdict. The ultimate goal in a case like this is to keep a conviction off your record and eventually get an expunction. Expunction is the way that you remove everything off of your record. You can deny that it ever even occurred. The two ways to do that are through a dismissal before trial or a not guilty verdict at trial. So that would be the best case scenario. Even on a felony case, though, most of the time, worst case scenario is you go to trial, and if you're convicted, you just get probation. It might be a couple years more probation, but there would be no reason to not fight it. If you have multiple prior convictions or it's a very egregious set of facts, there's a risk that you would be going to TDC to do prison time. But that's something we would discuss before trial, and you would know all the risks before we go to trial. Okay, last question for today. Why should I fight my DWI if I know I was drunk? That's a great question. I have a lot of people that come in and they say, Tyler, what can you do? I mean, here's how much I had to drink. I know I was intoxicated. How can you help me? There is never a case that I would say at the beginning that nothing can be done. Sometimes there are cases where nothing can be done. We do everything that we can. We look everywhere we can. We turn over every stone and we do a thorough investigation, and we just can't find any problems with the case. And occasionally we will advise that a plea bargain might be your best situation. But I mean, that happens maybe like 1 or 2 out of 50 cases. So it's very rare. Most of the time we can find some problems that make it reasonable and seem like the right thing to do to go to trial. There was a particular client, female, who came into my office, and she had a very high BAC, and she got in a wreck, and we told her our fee, and you know, it's not cheap. It's pretty high, but it's because we have the experience and we back it up with results. Her husband did not want to pay our fee. He said, "There's no way that you can get off of this. I don't even know why you're fighting it." And she didn't believe that, and she wanted to hire us, so she did. She paid our fee, and we were able to make her case go away. And the husband was he was shocked and pleasantly surprised. And then he ended up getting his own DWI, and he didn't have any question about why to fight it or why to hire an attorney. He hired us. He put his trust in us, and we're going to work on that for him. But your attitude should never be, I shouldn't fight this. I should just go ahead and take my punishment. Because you know what? You never know when you could have one beer or two drinks and not be intoxicated, and you're driving down the road someday and you're looking at your cell phone and you swerve a little bit and the cop pulls you over. He smells the odor of alcohol on your breath, and guess what? You're done. They've already made up their mind that you're going to jail. And the person comes into my office and says, "You know what? I wish I would have fought that first one, but I didn't think there was anything we could do." So there's never a good time just to say, I'm not going to fight it. I'm not going to hire an attorney. I'm just going to plead guilty. Always consult with an attorney. Many times there are things that we can do to help you out. If there's a way to keep it off your record, it's worth it. There's good motivation. It can be extremely expensive. If you don't keep it off your record, it can cause you missed job opportunities in the future and other complications in life as you go forward. So anyway, all right, I got to get back to the training. I really enjoyed speaking with you today, and thank you for the great questions. Please tune in next Friday at 2 o'clock. We'll be doing it again. And my name is Tyler Flood. I'm a Texas DWI attorney. I'm board certified in criminal defense. I'm located in Houston, Texas. My email is tyler@tylerflood.com. My phone number is 713-224-5529. Tell all your friends and send us some more questions. You can also email me your questions before the web chat next week, and we'll answer those. All right? All right, signing off from Chicago. I will see you guys later. Give you a quick little backdrop of the beautiful downtown skyline. All right, that is all for today.